All right, so we've got a pretty interesting stack of documents here. Looks like we're diving into the world of Indian real estate. Specifically, what happens when those big development projects hit a snag? When things go south and a project goes bust, what happens to the people who've, well, invested their life savings?
Yeah, it's a crucial area. And you've pulled together some really key sources here. We've got excerpts from a recent judgment. Looks like it clarifies a pretty significant 2018 amendment to India's Insolvency and Bankruptcy Code, and also the report that actually led to that amendment being made. Plus, we've got sections of the Real Estate Act itself. That's the RERA, right?
Exactly, RERA. So mission impossible, should we choose to accept it, is to crack this legal code. What does it all mean for the everyday person in India who's just, dreaming of owning their own home?
Yeah, decoding the legal jargon. Yeah. I'm in. And I think one of the most fascinating things here is how things were before this 2018 amendment. Before that, if a developer went bankrupt, homebuyers, or allottees, as they're called in all this legal language, were basically in limbo.
Limbo? That can't be good.
No, not at all. The main insolvency law, that code we talked about, it really just focused on two main groups: the financial creditors and the operational creditors.
Okay, I have a feeling those terms are going to come up a lot. So maybe break it down for us regular folks.
Sure. So think of it like this. Imagine a developer needs money to build a project. So they go to a bank, get a loan. The bank, in this case, is a financial creditor. They lent the money. Now, you also have the construction company, the one actually building the homes. They're providing a service, so they're an operational creditor.
Okay, I'm starting to see the picture. But where does that leave the home buyers themselves in this whole equation before this amendment?
That's a good question. And the answer is not good. They didn't really fit neatly into either of those categories. And because of that, they didn't really have much power if a developer went under.
That sounds, well, pretty scary for anyone buying a home.
Definitely. That's why this 2018 amendment was a big deal. It specifically said, hey, homebuyers, you're now financial creditors. And that changes the game completely.
Okay, I think our listeners' ears just perked up. Financial creditor. What's the magic in those words?
Well, for starters, it gave homebuyers a way to actually initiate insolvency proceedings themselves if a developer defaults. They didn't have that kind of influence before.
Wow. So no longer just sitting back hoping for the best. They've got some teeth now.
Exactly. But not everyone was happy about this change. There was definitely some pushback, a lot of it from developers themselves.
I bet. What were their arguments against giving home buyers more power?
Well, their main argument was that this was giving home buyers special treatment, compared to other creditors, like those suppliers we talked about.
But how are homebuyers really any different from other, unsecured creditors who are owed money? If the developer's out of cash, everyone's kind of stuck.
That's what developers argued. They said it would lead to too many insolvency cases, too many petitions, and just generally destabilize the industry. Plus, they felt that RERA, that real estate specific law, already offered enough protection.
So a real legal battle brewing here. Developers on one side, home buyers on the other. Which side did the court favor?
They decided to uphold the 2018 amendment. But it wasn't a straightforward decision. They really dug into all the arguments and gave a lot of detail in their reasoning.
Okay, I think our listeners are going to want to hear this. Why did the court ultimately side with the home buyers? What swayed them?
One big point was that the court recognized homebuyers actually provide financing to these developers. By making those, big upfront payments, they're investing in a future asset, unlike a supplier who provides stuff after the fact.
So the court's seeing them as taking on real financial risk.
Right. And they also saw that homebuyers have this unique stake in the project. They really want to see it finished.
Yeah.
It's not just about getting paid back for them.
It's their future home on the line, not just a business deal.
Exactly. And while the court agreed that both RERA and this insolvency code are important for protecting homebuyers, they said that in case of any conflict, the insolvency code would be the one to follow.
Okay, good news for homebuyers. Developers? Maybe not so much. But this judgment went deeper than just who wins.
Oh, yeah. Yeah. It actually delves into the very definition of financial debt. Like, what does that really mean? And that gets to the heart of why homebuyers now qualify.
I'm sensing some legal deep diving coming up.
We're about to get technical. But trust me, it's fascinating stuff.
Well, for that, our listeners are going to have to join us for part 2. All right, so we're back and we're ready to delve into the nitty-gritty of how the court arrived at this whole new idea of what financial debt really means, especially when it comes to home buyers. You were about to unveil the secrets of this legal code breaking.
Yeah, the court used these really specific tools. One of them was like looking at the context of how the words are used. The idea that, the meaning of a word can change depending on the words around it. It's not just looking at financial debt by itself, but as a part of a whole sentence, the whole legal phrase.
So it's like a cryptic crossword puzzle. One clue kind of helps you unlock the others.
Exactly.
Hmm.
And in this case, the phrase that became super important to the definition of financial debt is consideration for the time value of money.
Okay, I'm already lost. Can we translate that into like plain English?
Sure. So in the legal world, consideration usually means something of value is being exchanged, right? And time value of money is this idea that that money you have today is worth more than the same amount in the future. Because today you can invest it, it can grow.
Okay, so if I'm following this correctly, consideration for the time value of money means someone's giving up money now, but they expect to get something even more valuable later because that money, well, had the potential to grow.
You got it. And the court looked at things like commitment charges that home buyers pay, those upfront fees to developers. They're not just random fees. They're like payments for the developer's promise to actually deliver a finished apartment later on.
So it's like the home buyer saying, look, I'm giving up this money now, trusting you to give me something even better later on, a place to live.
Exactly. And those upfront payments, especially for projects that are, under construction, the court saw those as contributing to the financing of the project.
Even though it's not a formal loan, it's kind of having the same effect. The home buyer's taking on some of the risk.
Right. And the court even noted that home buyers often pay less for an apartment that's not built yet compared to buying one that's already done,
Yeah.
right? And that price difference is kind of like accounting for the time value of money.
Like they're giving the developer a discount in exchange for shouldering some of that risk.
You got it. And all this analysis led the court to say, hey, home buyers, you are providing financing, just like a lender would.
All right, so the financial debt piece is starting to make sense. But you mentioned deeming fictions earlier. That sounds way more interesting than financial debt.
Deeming fictions. This is where the law gets really, really creative. It's basically saying, okay, we're going to pretend something is true, even if it's not, to achieve a specific goal.
So legal make-believe.
Yeah, kind of. And in this case, the 2018 amendment, it uses this deeming fiction to say, look, even though home buyers aren't like officially lenders in the traditional sense, we're going to treat their payments as if they were loans, at least when it comes to these insolvency proceedings.
So the law is kind of creating a shortcut here, making sure home buyers get the same protections as banks and other lenders, even if the situation's not a perfect fit.
Exactly. It's a tool that allows lawmakers to address a problem without having to rewrite a whole bunch of laws.
Pretty clever. Makes you realize how much thought goes into these legal systems. But this judgment, it wasn't just about definitions, right? It also looked at how this amendment plays with RERA, that other law we talked about.
Yeah, that's another crucial piece. How RERA and the Insolvency Code work together, or maybe even like which one is the boss when they disagree.
Like figuring out which law gets the final say.
That's a good way to put it. So RERA, that was really designed to make sure developers play fair, requiring them to set aside funds from buyers in a separate account for the project, stuff like that.
So RERA is like, okay, let's keep this industry running smoothly and let's make sure developers follow the rules. But the Insolvency Code, that's like the emergency plan when things totally crash and burn.
Exactly. And the court said, look, both laws are important for home buyers, but they made it clear that if there's ever a clash, the Insolvency Code is the one that wins out.
It makes sense that the law dealing with a financial meltdown would have the final say. It's not just about real estate, right?
Right. And the judgment said that home buyers can use both laws.
Mhm.
It's not like you have to pick one or the other.
So if you're a home buyer and you're having problems, you've got options. RERA if it's, delays or defects. But if the developer's really in trouble financially, then the Insolvency Code comes into play.
That's right. It gives home buyers more flexibility to choose the best legal strategy depending on the situation.
So we've seen how this judgment really dug into what financial debt means, got creative with these deeming fictions, and even sorted out this hierarchy between RERA and the Insolvency Code. But there's got to be more to this story.
There is. One of the big worries that developers had was that this amendment, giving home buyers all this new power, it could actually be misused, like giving them too much power to disrupt things, even for small problems.
Sounds like that could lead to chaos, especially in a world as complex as real estate.
We'll have to unpack that in part 3.
All right, so we're back. And we've been digging into this landmark judgment, figuring out how it's changed the game for home buyers in India. But before we wrap things up, got to talk about, well, the elephant in the room, right? That this whole amendment, while it's meant to protect home buyers, could it also backfire?
Yeah, that's a real concern. The judgment itself actually mentions this, that some developers worried this could be, misused.
Yeah, you can imagine, right? Someone's just impatient, or maybe they just want to back out of a deal. Suddenly, any little delay becomes like a reason to trigger this whole insolvency process.
Exactly. And instead of being, a way to protect people when a developer's really messed up or is in real financial trouble, it could become like a weapon for anyone who's just unhappy, even if the developer's doing everything right.
That doesn't seem fair. Wouldn't that make developers, I don't know, hesitant to even start new projects? Too much uncertainty?
It's definitely a possibility. But the judgment, it does try to address this. It points out that there are safeguards built into the system to prevent that kind of thing.
So it's not like anyone can just, shout fire and bring the whole thing to a screeching halt.
Right. Remember, the Insolvency Code, it requires a serious assessment of whether a default has really happened before they'll even consider an insolvency petition. It's not enough to just say, oh, there's a delay. You got to prove the developers really dropped the ball.
So there's got to be real evidence, not just someone feeling a little annoyed.
Exactly. And the court talked about the NCLT, the National Company Law Tribunal. They're the ones who handle these cases. They have the power to really scrutinize each petition, and decide whether it's legit.
So they're like the gatekeepers, making sure only the real cases get through.
It's a good way to put it. And the judgment also highlighted the importance of RERA in resolving these disputes. Remember, home buyers can go to the Real Estate Regulatory Authority if there are issues with delays or defects, stuff like that.
So it's not either, right? It's like having different tools for different jobs.
Exactly. For small problems, RERA might be the way to go. But if a developer is really heading towards insolvency, well, then the Insolvency Code is the more powerful tool.
Like having a toolbox, right?
Yeah.
Different options depending what you're trying to fix. But didn't the amendment itself try to stop this misuse problem?
Yes, it did. It built in some safety measures. Like, to file a petition, you need a certain number of home buyers to come together. So it's not just one person with a small complaint causing trouble.
It's going to be like a widespread issue.
Right. And the judgment makes it really clear that the point of the Insolvency Code isn't to punish developers. It's to find a solution that works for everyone. Ideally, that means getting the company back on its feet so they can finish the project and people can actually get their homes.
So it's not about winners and losers. It's about trying to make things right.
Exactly. And the court even pointed out that having home buyers on that committee of creditors, which is, a direct result of this amendment, that can actually help make that happen.
Because now the people who are most affected, they get a voice in how things are sorted out.
Precisely. So while the worries about misuse are understandable, the judgment really argues that this amendment finds a balance. It gives home buyers more power, but it doesn't make things so one-sided that developers are at a disadvantage.
It sounds like a delicate balancing act, trying to make sure everyone's interests are protected. But it's also, I don't know, it's kind of cool how the law is constantly changing, adapting to new situations.
Absolutely. This is a great example of that, how the courts can use these tools to figure out these complicated issues and make sure the law keeps up with how society is changing.
Well, we've definitely covered a lot of ground here. We've seen how a seemingly small change, just adding home buyers to this financial creditor category, it's had huge ripple effects. It's changed how these projects are financed, how disputes are resolved, the whole thing.
We've dug into some serious legal stuff, deeming fictions, who knew that was even a thing, and untangled how two pretty big legal frameworks, RERA and the Insolvency Code, how they actually work together.
It's been a journey, but in the end, it seems like this judgment really does offer more protection, more clarity for anyone buying a home in India. But as with anything legal, knowledge is power.
Couldn't agree more. The more you understand your rights, the better.
So to everyone listening, whether you're, a seasoned property investor or just starting to dream about your first place, stay informed, ask questions, and don't be afraid to get some expert advice when you need it.
Great advice. And remember, this is just one example. The law is always changing. Stay curious, keep learning. And as always, thanks for joining us on this deep dive.